Good day, and thank you for watching. If you are dealing with a dispute involving a trust or a will in California, you are likely facing one of the most complex and emotionally charged areas of the law. Trust and will litigation often involves family members, significant assets, and questions about fairness, intent, and legal responsibility. Today, I'm going to walk you through what trust and will litigation actually is when disputes arise, and what you need to understand to protect your rights. Let's start with the basics. A will is a legal document that outlines how a person's assets are to be distributed after their death. A trust, on the other hand, is a legal arrangement where a trustee manages assets for the benefit of beneficiaries. In California, trusts are commonly used to avoid probate, manage property, and provide long-term control over how assets are distributed. Despite careful planning, disputes can and do arise. Trust and will litigation occurs when someone challenges the validity of a will or trust, or disputes how it is being administered. These cases are typically handled in probate court and can involve a wide range of legal issues. One of the most common reasons for litigation is undue influence. Undue influence occurs when someone exerts pressure on the person creating the will or trust, causing them to make decisions they would not have made otherwise. This often involves situations where a vulnerable individual, such as an elderly person, is influenced by a caregiver, family member, or other individual in a position of trust. Proving undue influence requires more than suspicion. It involves showing that the person was susceptible, that influence was actually exerted, and that the result was an unfair or unnatural distribution of assets. Another common issue is lack of capacity. For a will or trust to be valid, the person creating it must have the mental capacity to understand what they are doing. This includes understanding the nature of their assets, the people who would normally inherit from them, and the effect of the document they are signing. If there are concerns about dementia, illness, or cognitive decline, these issues can become central to a legal challenge. Next, let's talk about fraud and forgery. In some cases, a document may be challenged on the grounds that it was created through deception, or that the signature is not genuine. These cases often require expert analysis and careful review of evidence, including medical records, witness testimony, and document examination. Another important area is trustee misconduct. Trustees have a fiduciary duty to act in the best interests of the beneficiaries. This means managing assets responsibly, providing accurate accounting, and following the terms of the trust. When trustees fail to meet these obligations, whether through negligence, self-dealing, or intentional misconduct, beneficiaries may have grounds to take legal action. Common examples of trustee misconduct include: one example is failing to provide financial records. Another is mismanaging trust assets. Third is using trust funds for personal benefit. And fourth is favoring one beneficiary over others. In these situations, the court can step in to remove the trustee, order an accounting, or require repayment of improperly used funds. Now let's discuss contesting a will or trust. If you believe a will or trust is invalid, you must act within specific time limits. These deadlines are strict, and missing them can prevent you from bringing a claim, regardless of the strength of your case. The process typically involves filing a petition with the probate court, presenting evidence, and participating in hearings or trial proceedings. These cases can take time and often require detailed documentation and legal strategy. It is also important to understand that not every disagreement leads to litigation. Sometimes disputes can be resolved through negotiation or mediation. These approaches can save time, reduce costs, and preserve family relationships. However, when resolution is not possible, litigation may be necessary to protect your interests. Another key factor is evidence. In trust and will litigation, the outcome often depends on the quality and credibility of the evidence presented. This can include medical records, witness statements, financial documents, and communications such as emails or letters. The ability to present and challenge evidence effectively is critical in these cases. Let's also address family dynamics. Many of these disputes arise between siblings, relatives, or individuals with long-standing relationships. Emotions can run high, and decisions are often influenced by more than just legal considerations. Understanding how to approach these situations strategically, not just emotionally, is essential. Finally, let's talk about protecting yourself. If you are involved in a trust or will dispute, there are several important steps to take. First, gather and preserve all relevant documents. Second, avoid making assumptions. Focus on facts and evidence. Third, be mindful of deadlines and procedural requirements. And fourth, seek experienced legal guidance to understand your options. In conclusion, trust and will litigation in California is complex, detailed, and often deeply personal. Whether you are challenging a document, defending a trust, or addressing concerns about a trustee, understanding the legal framework and acting strategically can make a significant difference. These cases are not just about documents. They are about protecting rights, honoring intentions, and ensuring that assets are handled properly. Thank you for watching. Stay informed, stay prepared, and take action when it matters.